IPR activities at the level of so accordingly, our college now does conduct this faculty development program on the title intellectual property rights in academia. So certainly it will be eye opener to all of us. It is being conducted for the purpose of creating awareness, because even there are certain studies which shows that awareness is very less, even among the staff members, among the academicians, among the students. So the government, UGC and other agencies, they are more concerned about creating much awareness about these IPR rights, as well as the laws relating to this IPR. So accordingly, this program has been organized in our college. Certainly, who will be the participants, it will be very useful to them. So I do hope that in the right time, this FDP is being arranged or organized in our college. With this, I wish this FDP program all the success. Thank you.
Much thank you to you for sharing your great knowledge with us, and your words of wisdom throws light on the importance of IPR.
It is a great honor for me to introduce and welcome our respected chief guest, Mrs. S.Gomathi Padma Thilaga. She is a notable patent agent, IP consultant, young and aspiring women scientist in KIRAN, Department of Science and Technology. She has an adequate knowledge in various aspects of IPR and is skilled in prior art search, patent drafting, and technology scan study. I am overjoyed to say that such a gifted and talented personality, our guest of honor, hails from Sivakasi. She has earned many academic qualifications to her grades. She has completed her Bachelor of Science in Biotechnology in Kaliswari University, Krishnanpuri, and has received her Master of Science in Food Technology in Anna University, Alappa College of Technology campus.
To her credit, she has completed many international certificate courses on advanced intellectual property as well, and she has attended numerous training programs. Her contribution towards research is really impressive. She has presented research papers in reputed journals, national and international journals. She has received a merit certificate in TOEFL and GATE exam with an excellent course. She has been often invited as a guest faculty in universities and colleges to deliberate on IPR and innovation. Altogether, she has delivered more than 30 guest lectures in various universities and colleges. Her success indeed ignites a fire in every heart that dares to dream. Today, it's our privilege to have you as our guest of honor. We thank you for accepting our invitation, ma'am. May I now request a powerful, profound, and brilliant guest of honor to address the gathering.
A very good morning, everyone. Am I audible?
Yeah, we are able to hear you.
Yes,
Good morning, everyone, and I'm very much thankful to the management, principal sir, and other coordinators, Mrs. Priya and Dr. Pratibha. And it's a privilege for me to address a group of faculties from the our eminent institution from my hometown, Sivakasi. I'm very much happy to address this gathering. So, intellectual property rights, as rightly mentioned by sir, the awareness is very less in academia, especially. So, in India, the scenario is changing, but the growth is very slow as of now. So, we are expecting so much facilitation from the government, as well as some industrial participation for taking up the intellectual property right in the academic sector to a very high end, because as we all know, in India human resource is very much high. So we have a very much expertise people in the faculties as well as researchers. So much research going on, but still we are lagging in the business aspect of our research. So that's where there is a lag. Industry people, they have their own business strategies. Everything is there, so they are very well aware of these patents and not only patents. Other than that, trademarks, copyrights, all these kinds of intellectual property rights. Industrial sector is growing very well with that, but in academia we are very much focused on sharing our knowledge, but we are not focusing on gaining something from that. So not only financial thing, it is something like getting recognition as well as financial benefits. So this is lagging in the current scenario. So after the release of National Intellectual Property Rights policy in 2016 by the Government of India, so these kind of awareness programs and all the facilitation from the government side also, they are very much doing very well in. So I hope. This session will be very much useful for all of you, and I understand there are people from diversified backgrounds and expertise. So I will manage accordingly so that people from arts, commerce, as well as science background, for everyone, these intellectual property rights is very much important. I hope this session will be very much useful to you, all of you. So thank you for inviting me. Thank you.
Ma'am, you can continue the session, ma'am.
Yes, ma'am. I am sharing the screen.
Oh,
Is it visible there?
no, ma'am.
Okay. Shall I start, ma'am? Is it
Yes,
visible?
ma'am. Yes, ma'am.
Yeah. Okay. So I have actually planned for the session to be having three segments. So in the first segment, I will give brief introduction about all the IPR. I understand all of you have so much awareness, and you are all faculties in the institutions. So you are already aware of these things. But still, I will give a little bit basic introduction about what are the nature and the all the forms of IPR. Later on, we will move towards patents and copyrights. So in this session, we will focus more about copyrights as well as patents. Okay. First, intellectual property rights. What are rights first? Let us understand the term. What are rights? Rights are actually any legal entitlement given by the government to the citizens. Okay. So legal entitlement, it means to have something, to own something, or to enjoy something. Okay. So government is providing the rights to the citizens, and these rights can be either general or exclusive. General in the sense right to vote, okay, right to freedom of speech. All these things are general rights. Uh, there is no exclusivity. That means it is general for all people. All citizens enjoy the rights equally. So no one is excluded from having those rights. Okay, once the citizen is once a person is a citizen of India, so he or she will be enjoying those rights. But there are certain rights which are exclusive in nature. These rights are given to a particular person or a group of people or a particular entity or organization or something like that, and others are excluded from having those rights or enjoying those rights. Okay, so intellectual property rights are exclusive in nature. This is provided to the particular group of people or a particular person or entity. Others cannot enjoy those rights. If someone is infringing, infringement is the term we use for violation of those rights. Okay, so if someone else is infringing, the owner of the rights can actually sue them. Okay, they can file case against them. So that is what rights are. These rights are exclusive in nature. And what is a property? Property is something owned by a person. Okay, so this property can be either tangible or intangible. Tangible means it can be sensed by our senses, it can be touched, it can be felt, it can be seen. Okay, but intangible, these intellectual property is an intangible property. It cannot be felt by our senses. Okay, so but it is in the it is not in the physical format. It is there. Okay, but the both tangible and intangible properties are enjoyed by the person in the same way. What I mean to say is, if we have a piece of land, what we can do with that? We can actually sell the land, we can rent it, we can do whatever we want to do with that. Okay, so and in the case of intellectual property also, we can do the same thing. It acts as exactly like the normal physical property. You can actually transfer your patent to someone. We use the term assignment. Okay, we can assign our patent or copyright to another person, or we can actually give it as a licensing thing, or we can gain our royalty. Licensing is nothing but renting a land. It's like renting a land. Okay, so these intellectual properties are intangible in nature. Intellectual, the term means we all know it is the creation of mind. Anything that is arising from the intellect of a person. Okay, so this property is an intangible one, and it is arising from the capability of a human mind. Okay, so for these properties, government is giving certain rights. These rights are given for certain period, only for limited period. So this person can enjoy the rights over that intellectual property. Okay, so these intellectual properties have some common characteristics. There are various forms of IPR: patents, copyrights, trademarks, and geographical indications. So many, we will discuss one by one. But all these have some common characteristics. One thing I have already told, that is exclusivity. These rights are exclusive in nature, and these are territorial. Territorial means, see, in India, if we get a patent, if we apply and if the patent is granted in India, we can only enjoy that right in India alone, because this is bound by Indian jurisdiction only, by the law of India. Okay, if we want patent in other countries, we have to apply individually to in every country wherever we want to have that. What I mean to say is, we have a technology, we have a patent for that technology, we are commercializing that technology. We can stop others from using that technology in India alone, because we have got only in India. There is nothing like universal or the overall intellectual property right. There is nothing like that. Okay. Other than that, if we want to apply for patent if we want to commercialize in US, we can actually apply for patent in US by their own procedure. Every country has their own procedure to apply. There is a common procedure to apply also, that is also there. That is also there. We will discuss in detail. But for every country, we have to get patent individually. There are certain things which can be patented in US but not in India. So it depends on their law. Each and every country has their own law. Okay. So next thing is to be registered or granted. It has to be applied. It has to be registered or granted by the government. Okay. So except one thing, copyright. Copyright, for that we don't have to actually register. I will explain it in detail later. So as a short note, I'm giving here, like for copyright, it is not mandatory to register it, get it registered. There is a procedure to register, but it is not mandatory. Okay. And next thing is validity period. All these rights are given for only a certain limited period of time. It is not given for universal, I mean lifetime, except this trademark and geographical indication. Okay. Even for that, we have to get it renewed periodically. Every 10 years, we have to renew it. If we stop renewing it, the validity will be lost. But other than that, for patents, we have validity period of 20 years. Okay, so like that, for copyrights, we have 50 years. Okay, so for every right, we have a limited period of time. Patents, for throughout the 20 years period, we have to renew it every 1 year. So it depends on the particular form of IPR, but all these IPR are given for a limited period only, and it is assignable in nature. Assignable means it can be transferred completely to another person, either for a particular remuneration or not. We can actually gift. If we have a property, we can gift it, right? So it can be gifted also, and all these properties are inherited as well. If someone is having a patent within the limited period, if he or she dies, his or her legal representative will be eligible to enjoy those rights. Okay, heir, son or daughter or whatever heirs of the property it is bound by our law only. So what is the benefit of this protection? Why government is providing these rights, and what is the overall benefit about it? Okay, so I told you it is given only for a limited period. It is not given for lifelong. Why it is not given for throughout? Okay, I'm the owner. I have done this research. I have a technology. I have written a book, and I am the author. Why I cannot enjoy the right throughout my lifetime or whatsoever? Why can't I do that? Because this is for, ultimately it is for social benefit, social as well as national benefit. Okay, so there should be a balance. If someone is given patent uh, for example, there is a drug which is for say example, we have this vaccine for COVID. If some company or some particular person is given right over that for throughout his life, or unlimited period, if we give, imagine how it will be. It is a very crucial drug which is very much essential for the society. Okay, so if someone is given that kind of power, how he will misuse it? Because it's a human tendency to actually have the greedy tendency is very common in human nature. So how he or she will behave in the future thing. So and the cost will be high, very much high. Only he will be enjoying that. Others cannot commercialize the same product. Competition will not be there. So there should be a balance between encouragement is necessary, as well as there should be some restriction. For that purpose only we have this balance. So at the personal level, we have the benefit of having recognition, or we can actually, the particular owner of the right can enjoy the revenue out of it. And once the personal level, it is he or she is satisfied, it will amount to national as well as social benefit. See, once this is why IPR is this much important means. See, if we know we have a property, then only we will take some action to protect it. If we don't, if the same piece of land, if we don't know that we are the owners of that particular piece of land, it will be wasted, right? So if only when we know, then we will actually, what we'll do, we will we will go and look out for the options, how we can actually use that land. Then only we will know. But in the case of intellectual property, we are not at all aware that we are the owners of the property. Every day we are creating intellectual properties. Every day, from the moment we begin to think on our own, we are creating from the every child is actually creating something every day. Okay, but we don't know how to. We don't know that we are the owners. Only when we know that, then only we will actually protect it and we will gain from it. Okay, ultimately there is a national and social benefit. So why IPR is this much important in academic institutions? As I already mentioned, uh, all these these regulating bodies, all these are nowadays very much focusing on IPR. Right. That's why we are having these many awareness programs all around India during these recent few years only. Okay. So why this much importance is given in academic institutions? See, in India, our DNA is like we like to share our knowledge. Sharing of knowledge is free. Sharing is one thing, and there should be a balanced gain from that as well. Okay, so if we are giving every knowledge in charity, so ultimately it may not be it has to give some back. I mean, it have to give some feedback, right? So feedback benefit should be there. So once the institution is having certain rights, and then if it is gaining some benefits, financial benefits from that, then only that amount can be used, recycled towards further research. So nowadays, all the academic institutions, we are actually waiting for the grants, financial grant from government bodies, industrial collaboration. We are waiting, right? So if we gain from our own creations, then it will be easy for it can be sustainable. Every institution has to be sustaining themselves, right? So for that, we need this awareness. We have to change this attitude of giving knowledge for free. Okay, giving knowledge is one thing. For getting that also, you might have heard about this story, like penicillin. When he invented, he did not patent it. Okay, because this is given for the public purpose, and he didn't want to gain benefit on his own. That was needed at that time. Hmm? But if we go on giving this knowledge for in every situation, if we do like that, so others will be misusing that. Okay, so for that also we have to protect it, and then we have to utilize for the social purpose. We have to protect it first. So this attitude has to be somehow incorporated into the institutions, academic institutions. Initially, the main purpose of this higher education institution was only teaching. Initially, okay, teaching was the purpose. Later, we moved on to research. Later, research was given so much importance. Then, from the research only, we are getting so much innovation. But here we stop. At the level of innovation, we stop. We just publish it. We give it. But it has to go in circle. It has to benefit the institution back. Institution as well as the author or the inventor. It has to benefit. So this circle has to be completed. From the by innovation, we have to do the actual protection of the IPR, and then transfer that IPR, commercialize it, gain money from that, and then focus back for research, further research. So it will make the institution self-sustained. That's why we are creating so many IPR cells in various institutions, and IQAC is forced to form an IPR cell. So that's the main goal of the our government. Okay, so what is the role of IPR cell? Nowadays we have in many institutions, even in private universities as well, they have IPR cells, but it is simply for it is being inert. Simply one or two awareness programs we are conducting, then we stop. That is not the purpose of IPR cells. Okay, these many activities they need to do. First, they have to they have to be the in-house consultant of the institution itself. So they have to give consultancy to every inventor or innovator coming uh, to the in the institution, coming to the IPSL. Okay, so they have to provide proper consultancy. So how what kind of IPR it can be, whether if it is a book, how to protect it, if it is a audio release or whatever it is, if it is a technology, how what are the ways we can protect it. All these consultancy, these IPSL, the people in the IPSL should be able to giving. Okay, so to the students as well as researchers and faculties. So and then we have to go for commercialization. That is next step. So in Indian scenario, we have IITs doing this job very well. But other than that, private universities also and private institutions, all even government institutions, they are not doing very well as of now. We hope for the best. Okay. So this is the guidance given by CPAM. CPAM is Center for IPR Awareness and Management. This is functioning under DIPP. So they have given detailed guidelines how the institution should actually draft their own policy, as well as how to commercialize it and how to how to make agreement between the innovator and the institution. All these things they have discussed in the policy. This is a draft. You can actually go through that in the website. And what are the forms of IPR we have? We have in India, we have patent, trademark, copyrights, and then that industrial design. We don't know the difference between patent and industrial design. I will let you know in a little bit later. And then farmers' rights and new breeds, new varieties, plant varieties, semiconductor IC layout designs, trade secrets, and geographical indication. Only for trade secrets, we don't have law. All for all the other forms of IPR, we have patent. For patent, we have Patent Act. Trademarks, we have Trademark Act. So according to that only, we will the government will be assessing the application and giving the IPR to the particular applicant. Okay, so we will just I will give a glance of every form. Later we will move on to patent and copyrights especially. Okay, so trademarks, you all know in a brief sense, like all the designs, logo, or any particular brand name, all these things are coming under trademarks. For that also, we are actually using our intellectual capability to create some logo, create some innovative word, something like that, and then we are the particular company or the particular organization is able to link that link that trademark with their product, so that the consumers will be able to recognize the product by the trademark itself. So the quality aspect and the origin of the product, all these are how somehow linked to the trademark. Okay, so this trademark itself is having that much value. The brand name Apple, the brand name itself, it is having huge value. If once they transfer that, if a company is acquired by a big company, then for their trademark itself, they will actually by evaluation, trademark will itself have the huge amount of value. Okay, so these trademarks should be distinctive in nature. It should not be descriptive. What I mean to say is like we cannot have a trademark like a ceiling fan. Okay, crunchy biscuit. We cannot have trademark like that. It should not describe the product. It should be somehow distinctive in nature. Okay. So, like I said earlier, like these trademarks are given for unlimited period, but it has to be renewed every 10 years. And these are various types and categories of trademark. For if it is for a product, it is a product mark. It is for a service, like for lawyers, they have a particular mark, right? Service mark also, this beauty parlor or doctors, medical service, all these services, that is service mark. Certification mark is like for BIS, AGMARK, and FSSAI, all these things, they are providing certification. For that, they have a logo, right? So that is certification mark. Collective mark is like for doctors, they have a particular symbol. For lawyers, they have a symbol. CA, they have a logo. So all these are collective mark. Group of people have using the same mark. And well-known mark, this is something like, for example, Amul. Amul, we all know it is for only for dairy products. Amul is engaging business only in dairy products. Okay, but we cannot use the mark Amul in any other kind of product or service. See, I have an electrical appliance. I cannot use the brand name Amul for that electrical appliance because it is recognized by government as a well-known mark. It has established its reputation that much. Okay, it has to be recognized by the government. Once it is recognized, we cannot use the mark in any class of the trademark. There is around 45 classes of products and service. Okay, once we apply for a trademark, we will use the class number only for the particular class. For food products, there is a class number. So in that particular class only we will apply. But in case of well-known marks, all the classes are covered. Okay. So categories, the name Bisleri name itself, we can that word itself we can register for as a trademark. Device mark is nothing but we will use that name. The Bisleri is written in a particular font with a particular color, particular background, right? So that will be any logo, everything covers. It's covered under device mark. Color mark is like this purple color, Cadbury's, they have this purple color, right? So that is a color mark. Three-dimensional mark is nothing but for Kit Kat, that shape of that chocolate, that is actually a registered trademark, 3D mark. And sound mark, you might have heard this ting 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 ting. You might have heard this, and you must be knowing the product from the sound itself, right? So it's for Britannia. So this is sound mark. So somehow this the quality, all the aspects of the product is linked to the mark itself. So sound mark is also applicable in India. So these are various examples. This roar of lion in MGM. This thing also, it's a sound mark only. Okay. So next we move on to industrial designs. See, for patents are provided for the technical features. Okay, but industrial designs are provided for the appearance of the product, only for the aesthetic aspects. I'll give you a simple example. Normally we have a water bottle. In that, we need small kids cannot use the water bottle, normal sized and normal shaped water bottle. Okay, so now we incorporate a straw into the cap of the bottle. There is some technical aspects. Okay, how the straw is inserted and how much length it has to be, in what shape it has to be, how once the child sucks that through the saw, through the straw, how it will go. All these technical features are covered under patent. Okay, but while incorporating that, there is a change in the appearance of the bottle itself. There is a change in the aesthetic aspect, how it is visible, how it is seen by eye, naked eye, how it is seen. So that as aesthetic aspects itself, we can apply for design registration. These two are different in India. In US and all, they have design patent, but in India, we don't have the term design patent. We have two different registry for that. I mean, patent granting authority is different, industrial design authority is different. So we have to apply it separately. Design registration does not cover technical aspects. Okay. So these are some examples for everything. For every product, we can apply for the design registration. And this is a peculiar one in India, especially rights for the farmers as well as for new plant varieties. See, in agriculture universities and all kinds of research works and breeders also, general farming breeders, they are coming up with new plant varieties every day, and these have to be they have to be actually protected, and they have to be given certain rights for that. That is also an intellectual capability, right? So for that, we have this particular form of IPR. This farmers' rights is like certain wild breed of plants. Farmers might have conserved it for so long. Okay, this is not for new varieties. New varieties is different, and some conserved varieties also there. So for all these things, government is providing certain set of rights. Okay, this is under the criteria novelty, distinctiveness, uniformity, stability. All these things are checked by the government, by the authority, and then they are provided with the rights. Okay. Universities, research organizations, even common farmer or breeder can apply for these rights. So what are these rights? To produce that, sell, market, even import as well as export the variety. And this is also a unique thing, and this is new in Indian scenario. We have registration for IC layout designs and the layout of the transistors and other circuit elements. All these also we can. This is a different registry. We have a separate registry for this. Okay, but only few applications have come up as of now. And then we have trade secrets. This is nothing but certain things we don't want, the company or the person may not want to disclose to the public, may not want to register it as a patent. For example, for patent, everything has to be disclosed. That every detail of the technology or the invention has to be disclosed. Only then a patent will be granted. Okay, and that is also given for only 20 years. After 20 years, the patent will be given to the technology will be given to the public. It will be in the public domain. So anyone can use that technology after the expiry of 20 years. So, certain things the company may not want to register it as a patent. Okay, so they wanted to have as a confidential information. Then they will use it as a trade secret. There is no separate legislation for that in India. Some employee agreements, all these things, they actually manage these trade secrets. For example, KFC, the ingredients. Yes, this is mostly applicable only for the products which cannot be reverse engineered. In case of mechanical devices and all, we can reverse engineer it. Anyone can reverse engineer it by knowing the features of the product itself. Okay, but some chemical compounds and all, we cannot reinvent it. Okay, so in those kinds only trade secrets may be applicable. This is another important form of IPR, which is geographical indication. Recently, you might have heard many news, in Tamil Nadu. Recently, we have registered Kodaikanal Malaipundu. We actually did through Tamil Nadu State Council for Science and Technology only. So recently, many other along with that, we had this Erode Manjal. All these unique, peculiar products from a particular geographical origin, specific origin. In that geographical location only, it has the quality of the product is having that much reputation, as well as it is of very high quality. It is different. It is unique. from other products from other geographical locations. Okay, in that case, we can apply for geographical indication, but this right is given for a group of people. It is given for a community. All the producers in the particular geographical location is given. For example, Madurai Malli. So any producer, any farmer in the Madurai area, then they will be enjoying that right. Geographical indication and trademark are similar. This is like here also we will have a logo, and that particular producer or the manufacturer can use the logo. Okay, so these are some examples in from Tamil Nadu. Okay, Tanjavur dal, and then the Coimbatore wet grinder, Kanchipuram sari, all these things. So this I already told you, only a group of people, association can apply, not individually, not a single person cannot apply for the geographical indication. Group of people are given this particular right. Okay, and it cannot be assigned to other people also. It is not assignable. All other forms of IPR are assignable, but this is not assignable. Okay, so we have to give the evidence for all these things, like it should have unique quality, and it should be linked to the relation. It should have some linkage with the geographical environment of the location of the where it is origin. Okay, and all these things we have to disclose, how the method of obtaining the product, and the producers list. Some if it is an association, all the producers, they have registered with that association, all those links and their signatures, everything has to be provided. Along with that, we have to provide a map of the geographical location as well. So now we have this patents. Patent is very, very important in academia. So much research going on, and we are coming up with the various processes and products every day, but we publish it simply. That is we don't have the attitude of how thinking about commercializing it. Okay, so if we think about commercialization, then only we will think about protecting it first. Only when you protect it, then only we can commercialize. Okay, once it is published, it will be in the public domain. It is like giving for charity. You have to apply patent first, then only protect, then only we can publish it. But this is very important thing. And what are the what can be given patent? What are the things which are eligible to get patent? Okay, those things we will discuss in detail. Any technical solution to a problem is given the right. Okay, so see, patent can be given for simple things also. There are certain myths about patents. Okay, patent is only for science people or high-end researchers. Is only for patent is nothing like that. Patent is for every person who has an intellect. Okay, from safety pin to satellite, we can patent it. So it can be very simple. Also, it can be very complicated machinery also. But equal rights are given to both. There is no weightage based on the simplicity of or the complexity of the invention and all. Okay, this is one myth. Other than that, even 4-year-old kids have patents these days. Okay, so it is not like only for science people, only for research. It's not at all like that. Okay, so for that only I have given this example. You all know this paper clip. Every day we are using it. See, this was the first version of it. See, the estimation of the value of this, all the paper clip patents around this one particular invention only, there are about 400 patents. Everything is different in one aspect. So imagine how simple it is to get patent. So that it is estimated to be $80 million total patents value. it is not valid right now. That's why we are getting these clips so easily. Everyone is producing this, right? Initially, only for the particular period of time, it was only for the it was enjoyed only by the particular applicant. These many variations are there. For every piece of paperclip we are using, if the patent is valid, the applicant, the owner of the right, will be gaining amount from that. We are indirectly paying. If we are buying a mobile phone for a smartphone for 10,000 rupees, but we are paying around more than half of it indirectly to the patent owners of the technology, every technology in the mobile, in the smartphone. Like that only, these owners of the rights enjoy their benefits, financial benefits. Okay. What are the criteria for patents? Why we cannot get patent for every invention? Okay, for a technology to be recognized as an invention also, we need to cross these three doors. Only when the technology crosses these three doors, then only it will be recognized as an invention by Patent Act 1970. Okay, first thing is it has to be novel. It should not be available in the public domain. It should not be it should not be known by the public before that. Somehow it has to be novel. Novel in the sense it should be new. Novelty is easy thing. This is first door is easy door. We can easily cross that. And second thing is inventive step. This is the critical part. Okay. It can be new, but it may not be inventive. I'll give you a simple example. See, in the public domain, we have a doorknob made of iron. Okay, so what is the problem there? It is getting, and the iron doorknobs will be getting rust easily. So rusting is the major problem. Someone is thinking about a solution for that. We have other materials like porcelain or any other kind of non-rusting materials which are already known. Okay, so in that, using that material, someone is making a doorknob. This is novel. There is no such a thing. The doorknob made of porcelain is novel, but it is not inventive. It is mere workshop modification of the already existing knowledge. So it is very obvious. It is obvious. Okay, so it is not inventive in nature. This is the difference between novelty and inventive step. Another example I can give, like if a product is having two components, A and B, that is already known in public knowledge. Other than that, our invention has components A plus B plus C. We have C. So this will be novel in nature. But sometimes, another example, two products are there in the market. One product is having components A plus B, another product is having components C plus D, and we are simply merging these two. They are working independently, and these two, we are making a product with the components A plus B plus C plus D. This is not inventive. This may be novel, but this is not inventive. Okay. This is the major difference between the novelty and inventive step. And third door is also easy. It has to have some industrial application. Patents, all these IPR is only for commercialization, for business and gaining financial benefit. So for that, it should be having some industrial application. Either it should be used in industry or it can be made in industry. Okay. So for these kind of awareness programs and all, government, to facilitate this IPR, we have various organizations. So I am not going through this one by one. I will share the slides. You can. It will be useful for the institution to all. This is my collection of data. There are other organizations too. For particularly for sensitization, we have so many organizations now and are giving funds for the institutions. We can do in collaboration with them. So it will be very much useful for the institution. training, for training of the personnel also, we have these many. You can go through this. I will share the slide. Okay, now we will move on to the procedure for patent filing. See, these are also registered patents. You can see this is zipper, right? This was registered in 1917. Now it is not valid. That's why we are seeing this in every day we are using in all the articles we have, right? In the cloths, in bags, everywhere we use this zipper technology. So imagine if it is valid right now, how much the owner of the patent will be earning now. We can imagine, right? So, but it is not valid now. And this Scotch tape, these things, it is estimated to be $97 billion. And it invention can be this much complicated also. It has more than 200 parts. Okay, but the solution it is giving is like the solution of this product is like, once the life of the bulb, we can see the bulb here, right? Once the life of the bulb is over, once it is expired, it will change the bulb. That is the only purpose this whole invention is serving, but it has more than 200 parts. So invention can be that much complicated also, and the purpose may be also simple. This is a simple purpose. This is not a very needed one, but it is industrially applicable. Okay, so these kind of inventions also are also provided with patents. So these are some funny inventions you can see, right? Here, this is a version of alarm clock, older version. See, once the clock ticks to a particular time, that frame will be falling on the head of the person. So this is actually funny. These kind of funny inventions are also provided with patents. So this I am giving all these examples to get you know to that patent is not a mystery thing. It is not like for high-end researchers. All for to make that point only, I'm giving all these examples. Okay. So in India, we have Patent Act from 1856 itself. This was the first Indian patent. This is from the diagram, you may think it is a very high, I mean, a very, I mean, high-end research thing. But the problem it solves is nothing but in ancient days, kings, they used to have this samaram, right? Mela fan ku badala, they used to have that. For that, they have invented a machine to drag that samaram. In Hindi, they call it panka, right? Fan is panka. So panka pulling machine is the first invention which was patented. So what are the criteria for patents? This I told you, novelty. And here we come to the important part. I already mentioned this. Publication will kill the novelty of your patent. Once it is published, even though you are the one who have published, it's on your name only, still it kills the novelty of the patent. Once the patent is examined, it will actually kill the novelty. And the inventive step, I discussed this with you. So inventive step is estimated by the economic significance or any kind of technical advancement. These two are the factors to determine the inventive step. It should have an industrial application, I told you. There are many exclusions from these patentability criteria. These three are important. First thing, these three doors are crossed, then it is recognized as an invention. But still, some inventions may not be patentable in India. This is only for Indian case. Okay. For example, there is a section 3. This exclusion is very important. First thing, any machine which is any invention which is contrary to the already established natural laws. These kind of inventions are not frivolous inventions, are not provided with patents. Next thing is commercial exploitation or primary use of invention which are contrary to public order. Someone is someone is inventing a key which can open any lock. any kind of lock which the particular single key we can actually open. If there is an invention, something in some invention like that, it will not be provided with patent. That person may not be, it will not be given with patent, because this is against public order, right? So, and gambling machine, all those things are not provided with patents in India. Okay. Also, it should not be producing any harm to the health, environment, or animal, plant life also. Okay, biological weapons and embryonic stem cell research is also sometimes it is debatable. And then mere discovery. There's a difference between discovery and invention. Invention should be new. It has to be invented by the inventor, but discovery is like it's already there in the nature, it's already there, you are just finding that it is there. Okay, that is discovery. For discovery we will not get patent. I will give you an example in this case. See, we are isolating microorganisms. Bioscience people, you will know, like we are isolating various microorganisms from various sources, from soil or water, wherever we want, we are isolating them. Once it is isolated, we are characterizing them, and it may be a new microorganism, but it is, I mean, new organism known to the knowledge, but it is already existing in the nature. We are just discovering it, it is there. Okay. Such kind of discovery is not provided with patent. Also, discovery of any metals, any minerals, all those things also are not provided with patents. But the process of isolation is there. No, the process, if there is inventive step and novelty, then for the process we can actually get patent, but not for the organism or for the product. Okay. This applies to everything from animal sources, from isolation of components from plants, phytochemicals, all these things it is applicable. For that compound, isolated compound, we cannot get patent. But the process of isolation, if it satisfies the three criteria, then it can be given the patent. I told you this. Naturally occurring microorganisms are provided with patent, but genetically modified ones are given. Okay, because genetically modified plants and animals are not patented, cannot be patented, but genetically modified microorganisms can be patented in India. Other than that, new form of known substances. In pharmaceutical industry, they used to do this thing. A particular, for example, see, aspirin, any kind of compound which is useful for the, which is very crucial for that drug. For that compound, they might be holding patent. Once that 20 years period is getting over, they will simply change the form of it, and then they will apply for patent again. Okay. This is called evergreening of patent. To have that, to hold the patent over that particular compound, they used to do these things, and in India it is strictly not patentable. Other countries are against us in this case, but India holds to our point. We don't give patents to any new form or new use of a known substance. Also, sometimes see, for example, for one compound may be having multiple health benefits. First time they will be applying for a headache, later they will apply for another purpose. Okay, for this wound healing property or any other property, they will apply like that. So this is not entertained in Indian law. I told you, the property, new use, mere discovery of a new property or new use, and mere admixture, simply adding salt. Okay, say for example, in a solution we have this sugar and color additives. This simple example, we are adding color, it's yellow in color, it gives the yellow color to the solution, and sugar, it gives sweetness to the solution. They are acting independently. There is no interaction or there is no synergistic effect between sugar and the color additive. Okay, but this is not, the solution is not patentable. But if sugar and salt is added, it may be having some synergistic effect. Okay, this is actually a very simple petty example. In the pharmaceutical industry, it is very much applicable. Okay, some compounds which are used together, some composition, and then by individually they will be having some activity. By adding them in together, some unexpected result will be there. Some high activity will be there. In that case, they are patentable. The same thing applicable for these mechanical inventions as well. So mere arrangement of various components without any interaction between them, they function independently. In that case, we cannot get patent. For example, umbrella with a fan. Umbrella, its purpose is different, fans purpose is different, and they are not interacting with each other. But see, another example, we have a camera in our mobile phone. Camera has a purpose. Mobile phone, a smartphone, it has various purposes. But when it is incorporated, it is not independently working. So how we are clicking that, how the technology involved is different. In that case, it is patentable. Okay. And the method of agriculture, nothing, it's not patentable. And method of medicine, how some doctor is actually giving treatment, how a disease is diagnosed, all these things are not provided with patents. Okay, this is not entertained, this is against morality, right? And then plants and animals cannot be patented. We have rights, new varieties right, plant varieties rights, farmers rights, that is different. But here, plants and animals cannot be patented, even though it may be genetically modified, but it cannot be patented. Okay. And then mathematical methods, business methods, algorithms, all these computer programs. This is very crucial thing in India. In US and all, we can actually you can easily patent our software. But in India, computer programs per se, this is important per se. But computer program which is incorporated with a hardware component can be patented. Okay. Simply app programming, all the softwares cannot be patented. And other than this, these literary dramatic work, all these are covered by copyrights, so these cannot be patented. And then method of playing game, any mental act, every person, every athlete or every performer will be having their own skill. Okay, that is also intellectual thing only, but it is not given patent. And presentation of information, this PPT has been prepared by me, but I cannot apply patent for that, but it is my copyright. It is covered by copyrights. Okay. Integrated circuits, I told you, we have other set of another separate registry for that. And other than that, traditional knowledge, anything already there in the traditional knowledge cannot be patented. It may not be documented well, it may be orally inherited or orally transferred, but any traditional knowledge cannot be patented. But any value addition, something has some, for example, in case of turmeric, this is a big landmark case, wound healing property of turmeric. See, in US, they actually, in a particular company, they filed for patenting of the some compound, I guess curcumin or something like that, for its wound healing property was patented. It was granted with patent. Okay, but that time, after the grant only, our government, CSIR, we actually filed case against them, and then we fought a lot. We've spent a lot of money to establish that it is our traditional knowledge. It is already there in our literature. We are using in day-to-day life. It's every small kid will know in India, right? Wound healing property of turmeric. So these things, but we had to fight a lot. We needed lots of literature survey and all to establish that. From ancient literature, they provided some. It's a beautiful story actually. Um, firstly, we gave a literature, and then we showed that we are using the turmeric for long, and then that particular company, they wanted to hold the patent somehow, so they narrowed down their claims. They narrowed down like, okay, we will use that wound healing property for surgical wounds, only for surgical wounds we will hold, like that they approached the court. In that case, we had to come back and we had to do the survey again. We had to find some literature. We found from other language, not in Indian language. I don't remember which language, but from other language, they found some literature showing that in the case of while after delivery, after cutting the placenta, they used to apply turmeric. This is equal to surgical wound, right? So somehow we won the case, but we spent lot of money for attorney purpose, not for government purpose. We spent a lot of money for that, and after that only we have this traditional knowledge database. We have a database now. In that, from all our Indian languages, from Tamil, Sanskrit, all Indian languages, all the traditional knowledge is transferred and it is translated to English, and it is there in the traditional knowledge database. When that case was fought, we didn't have IPR policy also, so we could not defend our case so strongly at that time. So now we have our traditional knowledge database to have that evidence. Now, other than that, any invention related to atomic energy is not patentable. Okay. Who can apply? Whoever is the inventor can apply. Also, if the inventor assigns to a person, he or she can apply. Okay. Assignee can be the organization. See, UP faculties or the employees of the organization, and they are using the resources of the organization to come up with the invention. So by default, the organization will hold the patent. There may be some agreement between the employee and the employer, but still employee should get the consent from the organization before applying for the patent. It is advisable to do so. But the thing is, for application, the fees varies. If the patent is applied by the individual, the fees is less, and it will be about say, for example, about 8,000 rupees for government fees. I'm talking about government fees, not attorney fees. For filing that patent, for individuals it will be around 8,000, and total fees. I'm telling about total fees, everything, all the forms, and for organization it will be 5 times more than that. Okay, so in that case, some organizations are allowing the employees to apply on their own and hold the patent on their own, and many institutions have agreement between them. Whatever the commercialization part they are doing, or how, whether the organization supports for the application fees and all these can be it's about the understanding between the inventor and the assignee. The patent office has nothing to do with that. Okay, and it can be applied through a agent, but it is not mandatory to apply to the patent agent. Okay, patent agent is like a lawyer. He or she will be able to do all the drafting part, everything, because the document application itself, it's a legal document. It's a techno legal document, exactly. Okay, so technical part, very well about your own invention, but the legal part you don't know. So for that only, we are relying on patent agent, but it is not mandatory to hold a patent, to have a patent agent to apply your application. Everyone can apply on their own. E-filing can be done. If for e-filing there is some concession, I will show you the fees later. For e-filing, we need a digital signature. Okay, so patent agents, we all have our digital. We must apply through digital signature. I mean, e-filing only we have to do. If the applicant wants to file on their own, they will. You have to have your own digital signature. Then only you will be able to apply online. Or physical filing, anyone can do. And these are the types of applications. Ordinary, convention. Ordinary is nothing but your invention arises from India and you are applying in India. This is normal. Ordinary invention and ordinary application. Convention application is like uh, international application. Other countries. If you want to apply to other countries, first you have to file application in India. Okay, or you should, two ways are there. One thing, if you don't want to apply in India, you have to communicate to the patent office and you have to get their consent. Then only you can apply for other countries, apply in other countries. Okay, this is convention application. 12 months period is there. Once we apply in India, within 12 months after the date of application, we have to file in other countries. We have to decide what all are the countries we want to apply for patent. So only 12 months period will be there. To get that period extended, we can apply it as a patent PCT application, patent cooperation treaty. This is nothing but many countries have come up together to form a treaty so that to ease up the process of application in other countries. But decision is taken by every country, every jurisdiction. They have their own law. So based on that only grant will be there. A patent granted a technology is granted with patent in India, but it may not be patented in US. It is not depending on each other. Okay. And then patent of addition is like, first we have applied for a patent. Later we come up with some improvement of the same technology. Then we can apply it as a patent of addition along with the particular first main application itself. The benefit here is we don't have to renew the patent of addition. Renewal fees will not be there for patent of addition. If we apply it as the separate patent, we have to pay renewal fees for both applications. But if we apply it as patent of addition, there will not be renewal fees. Okay. Then divisional application. Sometimes we apply we just apply with whatever research we have done, and we will apply simply. And the controller will look into the application and say that there are two or more concepts in that, two or more inventive concept in the application. For example, two inventions are there, so it has to be divided, and that the controller has the rights to direct the applicant to divide the application. So this will be divisional application. This will serve as two different patent applications. Okay. So this is a very brief flowchart for filing the procedure for filing the patent. This may be bit confusing. I will tell you briefly. See, first we file application. This is only for ordinary application. I'm telling. I'm not focusing on PCT application here. I'm giving the procedure for filing only in India. Okay. So first we can file it as provisional application or complete application. Provisional is, now you have done some preliminary work and you know the outcome. You can somehow know the expected outcome. Okay. That anticipatory outcome, so in that case you can file provisional application. This is to save the date. Because before you complete your work, someone may come up with the application before you, invention before you, and then file for the patent, right? So to save the date, we can file provisional application first. The difference between provisional and complete is like complete application, there has to be all the columns necessary. Application, claims is the important part in patent application. So in provisional, claims is not important. We may not give the claims in provisional application, but in complete we have to give. After filing provisional, we have 12 months time. Within that 12 months, we have to file the complete. If the complete is not filed, provisional will be abandoned. It will not be processed further. Okay. After filing, after 18 months, the application will be published. See, we are focusing on publishing in research journals and all, right? Once we apply patent, it will be published automatically in the patent journal. They have their patent office have their own journal. Every Friday, the applications will be published. Okay. So after 18 months, it will be published. There is a form, some fees about 2,500 for individuals. In that case, if we file with that, it will be published within a month. Okay, so this is also valid publication, but one thing is there is no peer review. It is not reviewed. It is not examined. Simply whatever we have filed, it will be published. It is not a guarantee for a grant. It is simply telling the public that it is someone has come up with an invention. Simply, it's like a newspaper article. Okay, but it is in the patent journal. After that, after publication, it will be examined. Here, this is important. We have to request the office to examine that. Okay, for that there is a form. So only when we request, only they will examine. If that form is not filed, it will be omitted after 48 months, abandoned. Within 48 months, we have to file. Anyone can file examination, but usually we file it along with the complete specification itself. We used to file the request for examination form also. Okay, and then after examination, controller will send us a report. First examination report they will send. In that report, they will give a detailed analysis of our application, whether all these three criteria I told you, all these, and then other than that, section 3 criteria, all those they will do the patent search, and then they will provide the report detail, whether it is what are the discrepancies in our applications. All those things will be very well given in the report. Now we have to defend our case. Without FER also, it may be granted. This is important to be noted. After examination, if everything is pakka, everything is very well, and then it can be getting patent right away. But if there is a that happens very rarely. But if there is a discrepancy, it will be given in the report. For that, we have to give a reply. Applicant or the authorized agent has to give the reply. Written reply we have to give. With in that, for every objection, we have to give the response, and then we have to defend our case. If they want to amend, if they want to change any claims or anything, any specification, we have to do that, do those things, and then we have to defend our case. And then if the controller is satisfied with that, he or she may grant the patent. Even after that, they may ask us to appear for hearing. Directly we have to with written reply we have given. After that, direct hearing will be there. In that hearing also, we can defend our case. Then if once every discrepancy is compromised, then it will actually they will give the grant. Certificate will be given. This is the general procedure. Before grant also, after publication, before grant, anyone can oppose our application. That is the purpose of publication. We are telling the public that this is this. Okay, this person has come up with this invention, and that's what the office is publishing. Anyone can apply for opposition. From other country also, anyone can apply for file the opposition petition. There are certain grounds. Not everyone can apply without any reason at all. There are certain grounds. With that, opposition can be done. When it is opposed, it will be communicated to the applicant. If there is no application, then the process I told you will go. Okay.
Gomathi
There is
ma'am,
yes, ma'am.
excuse me, ma'am. Some of the participants are again and again stating that they are not able to see the PPT because of the taskbar. So kindly move that stop sharing taskbar.
Oh, really? Okay.
Okay, okay. You can hide, ma'am, or you can hide that bar. Okay.
Okay. Okay. Okay. Okay.
Okay. Thank you, ma'am. Thank you, ma'am.
Okay. So where were we? Okay, opposition, right? If there is no opposition, it will go as such. No, and there is no delay at all. If there is opposition, it will be delaying. Okay. So other like FER, we have to defend our case in the opposition communication also. Then hearing, there may be hearing in that case also. Both the opposing party and the applicant has will be called for hearing. The controller will hear the both the cases, and then if the opposition wins, if controller is satisfied with the opposition, the patent will be denied. If the controller is satisfied with the applicant's point of view, then the patent will be granted. Okay, this is pre-grant opposition. After grant also there may be some opposition. This is the same process in a little bit complicated way. See, opposition can be before grant as well as post grant. Okay. After grant also, any person can apply. Any person interested can oppose. But there is some fees. Not everyone will be interested to apply. I mean, oppose a granted patent because the decision is done. Granting is like judgment. Like it is that it has been examined and it is given the grant. And the controller's decision is opposed. Controller is opposed. Okay, so in that case, some fees has to be paid by the opposing party, and in the opposing party cannot be anyone. Not any layman can apply. Only the person interested. Interested in the sense he or she should be having some. Somehow he or she should be linked to the uh, to the invention. Okay, so not any layman can apply, but pre-grant opposition anyone can apply. Okay, and the post-grant opposition has to be done within 12 months. Once 1 year period is over after grant, no one can oppose your grant. I told you there are certain grounds for opposition, reasons to be opposed. Okay, if the patent is obtained wrongfully, by illegal means, or it is published already published prior art is there, these are the grounds for opposing. This is to facilitate the examiner. Examiner is also examiner and controller. Both are also human. Okay, every search is not exhaustive. Once we search in the literature, either patent literature or non-patent literature, once we search, it is not exhaustive result we get. We may miss, any human can miss it. So it is given to the hands of public, so they will facilitate somehow to examine the process. This is also a part of examination only, this grounds for opposition and all. See, and if the invention does not involve any inventive step, if the opposing party is able to stand their point that it does not involve an inventive step, if they have the necessary evidence and all, then opposing party will win. Okay, so there are many kinds of things here. See, geographical origin of biological material. In case of patents, there are certain specific specific things the people of from biological inventions. See, there are certain things to be satisfied. First one is National Biodiversity Authority's permission. There is authority, National Biodiversity Authority, for using any biological resource from India. It can be microorganism, plant, or animal, or human material, anything. If we use it, we should get permission from our National Biodiversity Authority before applying for patent. Okay, at least before the grant, we must get the permission. This process is simple actually, 500 rupees fees, it can be done online. So, but any biological material, microorganism or any compounds from them, any particular enzymes from them, or serum from animals, any kind of biological material, if you are using, it can be either procured, commercially procured, or it can be from wildly collected from the plant materials, herbs, and all. They are collected from wildlife. Even then we have to apply for permission from National Biodiversity Authority. One thing is that. Second thing is, in the application itself, we have to mention the source and geographical origin of the material. It should be mentioned. And the third important thing is, in case of microorganisms, if it is a procured one from a depository or repository, we must give the accession number in the application. Wherever we mention that species name, we have to give it in the bracket. We have to give the accession number. If it is not deposited, or you have isolated a new microorganism, then you have to deposit it in the repository, and then we have to use the number here. Okay. And for isolated microorganism itself, we cannot claim patent, but while using that, we have to mention it. If we are applying for the process of isolation, we have to mention that organism, right? For that itself, we need to provide the accession number in that, and source and geographical origin also. Okay, these are important things. And till now we discussed about application in India alone. Yeah, other than that, there is two ways. One, I told you, one thing is convention application, second is PCT application. There are two ways to two kinds of procedure to apply for patent in other countries. Once we file in India, we may file to other countries within 12 months. This is convention application. From the date of filing of complete, not from provisional. From the date of filing of complete, within 12 months we have to file. So we have to decide what all countries within the 12-month period. If we cannot decide within 12-month period, we may go for PCT route. The fees will be higher than that, but through PCT, there is an organization, WIPO, World Intellectual Property Organization. Through them only we are filing PCT. Okay. So this PCT application, once we file within 12 months, we have to file. After that, it will be processed further. So through international search, there is an international search authority, international receiving office, everything is there. In these international search authority and all, they may be Indian office also. India is one of the international search authority. So we can file in India, and we can designate India as the international search authority also. What they will do is, they will, before examination, before entering into national phase itself, they will do some detailed search, and then they will provide a report. This search and report, for that we have to give some fees, right? For that fees will vary from country to country, from every authority. In Indian International Search Authority, it is less. In Europe, US and all, if we designate US and Europe and all, and it will be higher. Okay. So and the quality, everything depends on that. But they will also give some report. In that international search report, we will clearly know whether it will get patent or not. It will be more like an examination. They will do that, but it is not a decision. They are giving some suggestion to our application. Okay. So with that, for facilitating our decision to enter the national phase. With that, we can decide which all countries we can apply. All those things we can decide based on that. Important thing is, we get 30 months period. 30 months period we get. In convention route, we get only 12 months. Okay, but fees will be higher. For ordinary application, these are mandatory forms. Form 1 is simply this application, all the applicant inventors details, all will be there. And then form 2 is the drafting part. This is important. This is the actual specification we are giving. And form 2, after that, statement and undertaking. Form 3, declaration as to inventorship. These form 3, form 5, form 18 are very much important. 18 is mandatory. Okay. Other than that, other than this, if we want to publish it early, we have form 9. Many forms are there, and more than 30 forms are there. Okay, these are mandatory forms, basic forms. Okay, and the fees for basic form 1 for individuals, it will be 1600, and for request for examination it will be 4000. Okay, form 2 there is no fees. Form 3, form 5 also there is no fees. Only these two forms have fees. If we want early publication, it will be 2500. For see, you can see this fees category is it's categorized with the nature of the applicant, whether it is a natural person or a small entity, or it's whether it is a others. I mean, large entities like uh, universities, institutions, and all come under others. Okay, so the fees will be higher accordingly. I'm just giving the snapshot, I mean, first page of that fees. There's more than that. Okay. So I just skip the do's and don'ts that you can actually go through later, that we can move to copyrights simply, because copyrights is also very much important in the academia. So what are the things we can copyright? Literary works, dramatic works, these are 6 categories of copyright protection. Here you see computer programs come under literary works. I told you computer programs per se cannot be patented, but the software can be protected by copyrights. Okay, dramatic, sound recording, all these categories are there. And who will be the actual first owner? In patent, the true and first inventor will be the default owner. If it is not applied, if it is not assigned, it will be the owner. Here, default owner will be the author. In the case of literary, dramatic, artistic work, author will be the owner. And here, see, for musical compositions, composer will be the owner. Cinematograph, sound recording, and all. When the composed music is recorded in particular form, with a particular people voice, particular performers, then it will be the producer will be the owner. For photographs and all, photographers. Okay. So a small story to lighten up this sessions. So far we have gone to this patent procedure and also so much complicated. No? This is a simple some funny story. This fellow, this monkey, his name is Naruto. He lived in Indonesian National Park. There, a photographer, a British photographer, he came. He was actually trying to take photograph of this particular breed of monkeys. He was befriending them. He spent a few weeks there, and then he befriended them. And then find one day this particular monkey, he was very much curious about the camera and all. He clicked his own portrait. Okay, so this photograph, this is his selfie, right? So this photograph went viral like anything, and then he earned a lots of money. He wrote a book about his experience there, and he earned a lots of money. Later, after 4 years, this happened in 2011. After that, after in 2014 or so, Wikipedia published this photograph saying that this is in public domain. In public domain means no one can hold patent, no one can have the right, have the copyright. It is in public domain, like that. Because Wikipedia, they are commercial organization, commercial website, they are publishing in their website, right? So that is like violation. If it is owned, if the owner is with copyright, then it is violation. But they have published telling that it is in public domain. Later, after a year time, this photographer was offended by that. He was trying very best, his very best to get the photograph away from the website, but it was not happening. And then one day, this PETA, People for Ethical Treatment of Animals, they filed a case against this photographer in US court, saying that this ownership of that copyright lies with the monkey, not with the photographer, like that. Okay, so this case was very much very much important and peculiar one. Later point of time, this photographer went bankrupt, spending all his money earned from this photographs in the attorney for the attorneys alone. Okay, later this PETA, they no one won the case, but the thing is, they tried to settle it out of court. Finally, the judgment was like, no one actually holds the copyright. The judgment told like, this animals cannot be given copyright. This All these IPR, not only copyrights, all these IPR is for commercial purpose, only for human intellects. It was defended by in different ways. The photographer claimed that initially many photographs clicked by the monkey was not good. That he only changed some settings in the camera so that it will be clicked nicely. Like that, he defended his case. So his intervention is there, like that he defended the case. But PETA was arguing like, no, it's the intellectual capability of the monkey alone, like that something. And then, but court, the judgment was like, this is not, the monkey doesn't hold the copyright. It did not mention that the ownership is with the photographer alone. They just mentioned that copyright is not for monkeys. Okay, so this is on peculiar case, recent one. And what are the rights from copyrights? We say rights. What is the actual benefit from that? We have economic rights. In copyrights, we have moral rights also. See, economic benefit is one thing. Other than that, there is some personal link between the author and the work. Okay, if there is any distortion happen to the work, if someone is distorting the work, for example, if someone has transferred their rights to someone else, okay, only the economic rights are transferred. Moral rights lie with the author. For example, you are the faculty, an employer writing a book, and then the copyright is owned by the organization because he is paid by the organization. Okay, he is using the resources of the organization. So then the copyright is owned by the organization, but only the economic rights they can hold. They cannot take his name from the work. He has to given the recognition. He has to be given the recognition. He has to be given with the needed reputation. All these things. Any distortion to the work also, it's not allowed. Okay, for that also we can file case against the people. And what are the economic rights? To reproduce the work, to perform, broadcast, communicate, translate, adoption, all these things. See here, adaptation. Any work in translation, we know in different languages. For that also, we need to get the consent from the original author. Then, if it is not got, or you should give royalty to them. Any understanding should be there. It should be, the consent should be got. Okay. For adaptation also, from one form we are adapting to another form. Like from the novel, it is adapted to a movie. It is captured in one medium as a book, but it is actually transferred to another medium. In that case, it is adaptation. For that also, consent is important. Moral rights, the authorship and integrity of the work. So another simple story, like this person, Amarnath Sehgal, he is from India. He made a sculpture. Okay, sculpture. He was asked by Government of India to make a sculpture depicting all the cultural name. Depicting all the Indian cultural aspects And then mural was placed in the walls of Vignan Bhavan, the government building. Okay, there it was placed. After few years, time that mural got damaged. Somehow they actually the authorities took away that mural, and then they kept it in some dungeon or somewhere. They in the storeroom it was kept. This person, he was paid by government. He has transferred his rights. Okay, economic rights are already transferred, but he filed case against to claim his moral rights, because it affects the moral, it affects his morality, it affects his reputation, and in the that work is also distorted. And he fought a case like for more than 13 years, and then he won the case finally. That's the beauty part. He won the case. This is one peculiar case of a moral rights claim, right? Because his name written under the mural, that sculpture, in that it was also distorted. His name was also distorted. So that was weightage. That was a very good weightage for his case. And then and the government was asked to pay some money, around 50,000, 5 lakhs or some amount of money, some huge amount. Government was asked to pay him, but he refused to get the money finally. He wanted to win the case. He wanted to make his point. Okay, but he didn't receive money from, he didn't want to get the money from government. That's one peculiar case in India itself. And I told you registration of copyright is not mandatory. Copyright protection is automatic. That means once you create your work, once it is recorded in a medium, you cannot claim that I thought about this story already, so this is my copyright. Thinking is different, registering it, capturing it in medium is different. Whether you have to capture it in a book, in a written format, or it has to be captured in any electronic format, whether voice recording or in a typing format, anyhow, you should be capturing it in a medium. In that case, copyright starts from that moment. You don't have to have registration, but the important thing is you should be able to establish that, I mean, you should have the evidence that you are the actual author. That is the important thing. Okay, for that we need the registration. It is advisable to get it registered, but if you have enough evidence to show that you are the actual author, then registration is not at all mandatory. There is a procedure. I tell you in a simple words, like it is merely same, almost same like patent procedure, but not complicated like that. Simply we apply, and then for 30 days it will be waiting. Any objections for that? Diary number will be, diary number is nothing but application number. There will be a number will be generated, and then if there is no objection, it is more like opposition in patent. If there is no objection, and in examiner also will examine, any discrepancies will be communicated to the author. If there is no discrepancy, it will be registered. This is very, very easy procedure. In academic institutions, all lab manuals, everything can be copyrighted. It is given equal weightage in case of during ranking and NRF, all these things. Equal weightage given like patent. And the fees for this copyright registration for literary works, it is only 500 rupees. Okay, it is very easy, and discrepancies mostly don't come. Copyrights mainly are dealt in court only. Okay, while registering, we may not face anything. If someone is infringing our right, then only it will be dealt in the court. Okay. So copyright registration is very easy, even though it is mandatory, but it is advisable to have registered. What is the I mean 60 years period is there for copyrights. For patents it is only 20 years. For copyrights we have 50 years, 60 years. Performance rights only 50 years. These are different, right? So I'm not explaining this right now because it will be too much complicated to explain now. And this 60 years period is calculated from the beginning of the next calendar year. That means, see, today, even though by January 20, I am publishing my work. Okay, my that January 20, 2020, I'm publishing my work. My copyright will be calculated from January 1st, 2021. Even though if I publish today also, it will be calculated from January 1st, 2021. That is why we are mentioning only the year of publishing, publishing year only, year of publication only. We will mention in the books and all. You would have seen that with the symbol we use only the year. In the case of patents, the 20-year period is calculated from the date of filing date, not from the first day of year. Okay, it's not like that. But in copyrights, it is calculated from that. And assignment of copyright. This copyright is also transferable to anyone, to wholly or partially you can transfer, but moral rights are not transferred. Moral rights are independent of the author's copyright. It remains with the author only. Okay. So anyone infringes your rights. See, permitting any place where performance constitutes copyright. I mean, if someone is performing, singer, say for example, singer is performing in a particular place, the provider of the place, the location provider, the venue provider also may be liable for infringement. Okay. There are some exceptions. Certain things are exceptions. See here in this presentation is my own, is my copyright. Okay, not exactly I am the author, but I prepared this presentation during my tenure in Tamil Nadu State Council for Science and Technology. I'm using their logo because I am recognizing their ownership here. It is not mandatory, but I do, and here I'm not commercializing it. Okay, this is for learning and teaching in classroom. This is for teaching purpose. This is like teaching purpose. So here I am not infringing any of their rights. If I was employed there, I was provided with the fundings there to work for them, but still the moral rights lies with me. That's why I am using my name there. Okay, because I can tell this is my presentation, but I cannot commercialize this PPT. I cannot upload this in a website and then I cannot gain money from that. I cannot use this for my private business. If I have my website for my company, I cannot use this PPT there. Okay, that is commercialization purpose. But here, this is for teaching purpose. Even I can share this PPT with you all. You can also use for teaching purpose, not for other commercial activities. Okay, so these are some exceptions here for review and all. For performance to non-paying audience, these are exceptions. These are called as fair dealing, fair use. So this is also important thing. Plagiarism, we often get confused in academia. We used to get confused between copyrights and plagiarism. Plagiarism is like nothing but we are telling others' work as ours. We may not gain financial benefit from that, but telling that others' work as ours is itself it's called plagiarism. Okay, this is about morality. This is not about legal aspect. This is about morality. So this is a common difference between the two. Like copyright, we have law. We can, if our copyright is infringed, we can go to court. Plagiarism is about matter of ethics. There is no law. There is no act for plagiarism. False claim, telling that it is ours, getting without giving credit to the original author. These are moral aspects, ethical thing. Okay, it's not about law. Also, this is the bottom line impact will be economic in the case of copyrights. Here, even though economic impact is economic impact may or may not be there, but bottom line impact is reputation. Okay. So sometimes both may meet at some point, copyright infringement and plagiarism. First thing, see, when a person properly cites a source but does not have the legal right to use the source material. See, here I have used many pictures here and I have cited the source, but I don't have legal right to use the source material. Here there is an exception, teaching purpose, but still, if I commercialize this PPT, now this is actually, I'm not infringing, I'm infringing their copyright, but I am not doing plagiarism. This is not plagiarism. I have given the picture source at the bottom. I'm giving credit to them. I'm not claiming that it is my photograph. I'm not claiming that, but it is infringement, copyright infringement. If I publish it, I mean, if I commercialize it, okay. Second thing is when a person uses material that is not protected by copyright law, but does not properly cite. Both, like, for example, the poems of Bharatiyar or any other Rabindranath Tagore, these people, after their death, it had 60 years period is over. Okay, so now their works are not under copyright, under their copyright protection. So in that case, anyone can compile their works and then publish it. But anyone, if someone claiming that this poem is written by me, then that will be plagiarism. Even though copyright violation is not there, but that is plagiarism. Okay, because you can compile and publish it or commercialize it, but you have to mention it as these poems are written by Bharatiyar. Okay. So third thing is both does not cite the source and does not give credit, also commercially exploit it. Infringe the copyright. So is this plagiarism? We don't have law. I told you already. So certain institutions have their own set of remedies for these things. They have their own regulations. This is one such example from IEEE. They have their own regulations, how this plagiarism is prevented, or after when it is found out, then how they will act. See, from loss of privilege for publication to mandatory apology, all these things are there. Okay, this is one example. For in academic institutions also, they have, every institution may have some level of regulations regarding this plagiarism. So how to avoid plagiarism? First, cite it, whatever it is, cite the source, or at least give it in quote. Okay, if you have to give it is if you must mention it, give it in quote, or you can use a paraphrasing. Paraphrasing is also some, it's like Madil Mel Pune, Yenda Pakanalu Pura. It's like paraphrasing is also not so advisable, but somehow some morality should be there. And finally, best part we can do is summarize it. Like while writing a review article or whatever it is, if you want to get a glimpse of the work and then summarize the work, okay, that you can do in your own words and vocabulary. So that's how we can prevent plagiarism. This is actually out of the IPR aspect, but still I wanted to give this here. And see, this is like a take home message from this copyright presentation. See, this is how we mentioned, like Copyright Act 2019, this was done there. So copyright lies with Patent Information Center. I was an employee, but I'm using my name, I'm giving credit to them. Also, I cannot commercialize it, but I can use my name there because I was the one prepared this. Okay, even though if they want to commercialize it, they cannot deny that I am the author. They have to accept it. They have to give credit. Moral rights lie with me. Okay, so I will share all these 3 PPTs with you all. Commercial use of this presentation is prohibited, but for teaching and learning purpose, it's so free. So thank you all for your kind attention, and and it was a little tedious because we don't see the audience reactions and responses here. It's like talking, but we have to be accustomed with this kind of situation hereafter, right? So I'm very much happy to address all of you. Again, I thank the management and the organizers. Thank you so much. And you can contact me anytime. And in the PPT itself, I have given my contact details. Thank you again. Thank you so much.
Participants, now it is a question session. If you have any queries or if you need any further clarification, you can ask our chief guest. Participants, now it is a question session. If you have any queries, you can ask our guest.
And I
Good
can
afternoon, madam.
see. Yes, yes, sir.
Hello. Good afternoon, madam. I'm audible.
Yes, sir. Yes, sir.
Ma'am, I have small clarification
Yes.
regarding patent. Basically, I am from botany.
Okay.
Now I am doing as a wild variety plant to establish as a cultivation. So how to get a patent from the government, and if any steps are there for submitting proposals to the TNAU, I mean agriculture, because I am belongs to botany, but I am willing to single, like you know very well the famous vegetable in Adalakai, in botanical name called Mamadiga Zimbalaria. I want to, already I worked with this plant in the last 6 months. My aim and vision is to spread out this plant throughout the Tamil Nadu as well as in South India. I'm doing well with different contacts.
Hmm.
And I want to skip to this plant to next level, getting patent from the TNA. Is it possible now?
Sir, I understand your question as like this is a conserved variety. Is it so? Or it is a new variety?
This is not a conserved variety. This is wild one. Wild
Wild one.
one. This is not aware about other people's. This is the
Okay.
first time I'm going to stage that plant.
Okay, sir. So it is, I should mention here like plants cannot be patented. Okay, sir. So this is not applicable for patent. And also, this is it's mere discovery. It is mentioned. It can be mentioned as discovery. You have discovered it, but it is already existing in the system. It is in the nature.
Yeah,
You
yes,
have
ma'am. Yes.
this can be taken as conservation of the plant. Okay. So
Okay. Okay, ma'am.
if we proceed like that, we can approach the plant varieties and farmers rights authority. Patenting is not possible for that, but we can approach this authority, so that in that case they will do the processing, and then this is different set of right, not patent. We want to propagate it, and then you hold the recognition for what you have found, what you have discovered. See, all those things are covered in by them, not by patent office.
Okay,
So
ma'am.
yes, sir. You can approach
Uh,
TNSCST also. In TNSCST, we have a facilitation center,
okay,
or
ma'am.
in DST also they have patent facilitation center. All these things, they will be able to give more of what to say, how to proceed. All those things, they will be guiding you.
Okay,
And
ma'am.
resource aspect, if you approach patent facilitation center, uh, I mean in the DST, I'm not in TNSCST. TNSCST, we resource, I mean financial funding will not be there for filing and all, but
Okay, ma'am.
if you approach DST, you will get.
Okay, madam. I approach the financial funding agency, ma'am. I
Yes,
have one more doubt, ma'am.
yes,
Uh, I think I skip on to the next level. Getting from that plant as a value-added product. I'm going to convert certain value-added product. This is possible to kind of going for patent.
definitely, definitely. any product obtained from that, or any process of isolating any particular compound, or all those things can be patented, but not plant as such or the isolated compound as such. Even though if you isolate many compounds and then make a composition, if you make a composition of it and it has particular benefit, and then we can apply for patent. That is applicable for patent.
Okay. Can you give any suggestion for a separate website or any agencies?
In my slide itself, there is a list of organizations who will support for facilitation. So you can look into this. In biological resources and all, BIRAC also, yes, they also they provide fundings for research as well, also for patenting. So you can approach them. Also, National Innovation Foundation, there also you can approach. But one small problem in Indian scenario is these government facilitation takes time, because there internal scrutiny, all those things, it takes time. That is the only problem we face.
Approximately 3 years, ma'am. Waiting for 3 years.
Minimum 1 year, sir.
Minimum 1 year. Thank you, ma'am. Thank you. Thank you.
Right.
Thank you.
Ma'am, could you refer some important
Yes.
patent-related journals, ma'am?
Patent journal by patent office you can find in the website. So I will quickly 2 minutes I will show you the website here. I will show the presentation, because that will be even more helpful. I can see the questions in the chat box also. So, is my screen visible there?
Yes, ma'am.
Okay, so this is the website of our IP office. Here ipindia.nic.in. Okay, in this website we have patents, designs, trademarks, and GA. All details about these 4 we will get. Okay, here patent journal. See here journals. Here, if you click here, you will get into the list of patent journals as well as all these. Here, public search option is there. Here, if you click there, patent search you can do in the patent office website. I mean, patent office website itself. No, it's taking some time, so I just quickly tell you this. Am I audible?
Yes, ma'am.
Okay, your
Yes,
voice
ma'am.
was breaking. That's why I just made sure. Okay.
Ma'am, yes, your screen is not visible, ma'am. You couldn't see the
Okay. Wait. It shows it's shared.
Ma'am, actually the screen is not visible, ma'am.
Ma'am, try sharing again, ma'am.
Yeah, I'm trying. Is it visible now?
Um, Yes, ma'am.
Is it? Okay. Okay. So this is a website ipindia.nic.in. Patents, designs, trademarks, GI. Other than that, we have this copyright office. There is a separate website for that. For semiconductor IC circuits. Patent, if you want to file patent, there is a separate website, but in that portal you have to have digital signature to enter into that, to register and enter and all. So here, this is the website for copyright office. See here, e-filing. It's a very simple procedure. So we need to register it and sign in. Here, every detail is given here, how you have to fill that. Form 14 is a important form that we are filling. Simply, if you log in and if you just enter into that application form, you can fill everything. What is asked, like author name and the name, the article, and the if it is a literary work, title of that work, and the language of the work. If it is published, the published publisher's NOC has to be given. No objection certificate from publisher should be given, and all these things, it is very easy to fill. After that, we have to 500 rupees for literary work, other work, musical works and all 2000 rupees. For cinematographic work, 5000 rupees fees. If you pay it, and then we have to send the acknowledgement slip, everything to the particular office address. Okay, after that we can check our status here itself. Status of the application with the diary number generated, we can view the status here. Once it is registered, we will get the copyright certificate. This is very easy, easy way of applying. I would like to show the search option also here. See, the public search in the IP India website, when we go into the public search option, here you can search for the published patents. If we have filed and if you want to see the status, you have to click here. Or if you want to do the general search, you have to click here. Okay. For trademarks designs also, there is a separate searching thing. If you just go enter into that, you will know how to proceed with that. Okay. I just wanted to show this for a while. Yeah. Here, see, only published articles will be searched, will be shown. Okay, and publication journal will be in the home page. See, patents journal. Meanwhile, I show you the search here. See, there are plenty of options with using keywords, title, abstract, complete specification. If you know the number, or inventor's country, inventor's office, filing office, all these options are there. See, simply I'm searching in the title, like 3D. We have operators and or not. I advise all the researchers to do a search in patent databases. Okay, not only in Indian patent database, we have Google patents. See, all the titles with 3D is hit here. So you can see the application status. All the documents will be there. It is published, but it is waiting for examination. All the documents will be there. You have to go to the complete specification. There only you will see the details about all the form 2 is the complete specification. Okay. So like we do literature survey, we have to look into the patent database. This database shows only Indian patents. Google patents is very simple. Normal for prior art search, we can use Google patents. Here you can include non-patent literature as well. So scholar and patents are merged here. So I advise all of you to please do the prior art search and literary search. Before deciding your topic itself, please do search in patent databases, because about 80% of original research going on is published in the patent database only. Not so it is very much advisable to do the search here, because once you do review in the scholarly articles, later you decide a topic, and then if you proceed with your research, once you come up with a process or product, it may be already published, already patented one. Okay, so it's you have to direct your research towards the patentability. All these is very much important to have it in mind before starting the research itself. All the patentability criteria I have told you, all these things you have to know. Then only you can direct your research towards how to make your outcome to be patentable. Okay. So this searching, this will take some skill, but not that much difficult in Google Patents. There are other databases, Patent Scope, many paid databases are also there. But for academic level, for prior art search level, this is okay. For technology scan and all, we use the other databases. But this is very much easy to operate, and in Google Patents, we will Indian patent documents will not be hit. Okay, it's not shared here. So for Indian patents, you have to search here. For other patents, you can go for Google Patents. Okay, this I wanted to show you. Other than that, if you have any specific question, I'll answer.
Thank you, ma'am. With all our due respect, we would like to thank you for delivering such an inspiring speech and for sharing your deep, insightful thoughts to get patents for innovative ideas. We thank you for having this mysterious area clarified. Your comments were especially helpful to those aimed for getting patent. On the whole, the session was full of zeal and valuable information. Thank you very much, ma'am.
Thank you so much.
Gratitude is not only the greatest of virtues, but the parent of all others. I would like to invite Dr. V. Pradeepa, IPR Cell Coordinator and Assistant Professor of Biotechnology, to propose a vote of thanks.
Respected principal, vice principals, senior faculty members, members of faculty from various colleges. Good afternoon to all. On behalf of Sri Kaliswari College, IKC Cell and IPR Cell, I feel immense pleasure to take this opportunity to propose a vote of thanks for this online faculty development program on intellectual property rights in academia. First of all, I would like to thank Almighty God for making today's program a great success. I would like to express my sincere gratitude to our management and our Secretary Sir, Shri A.P. Selvarajan, for giving us support to organize this FDP. I would like to thank our Principal Sir, Dr. S. Krishnamurthy, for his constant motivation and keen support to organize this FDP. I also express my sincere thanks to our Vice Principals, Dr. P.K. Balamurugan Sir and Ms. R. Muthulakshmi Ma'am, who effectively guided us to organize this FDP grandly. I would like to extend a special thanks to our chief guest, Mrs. S.Gomathi Thilaga, IPR consultant, Women Scientist C, for her valuable lecture on role of IPR in academia. On behalf of our management, IKC and IPR Sir, I truly express my gratitude to you, ma'am, for accepting our invitation and taking out your precious time for this FDP. Our lecture on management and characterization of IPR in academic institutions, the importance of copyrights, and awareness about plagiarism are exemplary. I hope it imparted enough knowledge on IPR to the participants. I would like to thank our IKC coordinator, Mrs. L. Priya, for her constant efforts and support to organize this FDP. I would like to thank the technical team and non-teaching staff members who put their keen efforts to conduct this FDP through online mode. Last but not least, I must mention my deep sense of appreciation and gratitude to all the participants who are all the real beneficiaries of today's program. Once again, I thank you one and all. Thank you.